Thank you for joining us tonight. My name is Barry Erickson, and I'm Community Engagement Coordinator at Wheaton Public Library. ACES stands for Aging and Caregiving Engagement and Support. This monthly series of presentations is designed to be a centralized source of information and resources for seniors and caregivers. Tonight, we are proud to bring you this session of the ACES series on estate planning with Jim Flanagan, founder of the Bentron Financial Group. Bentron simply means an instrument of good, and Jim has dedicated his professional life to helping people retire successfully. Jim has a master's degree in finance from Dominican University, a master's degree in gerontology from the University of Southern California, and a PhD in philosophy with a concentration in leadership and gerontology from Concordia University in Chicago. So with that, I will turn the screen over to you, Jim. Thank you so much for being here tonight.
All right, thank you very much for having me tonight. It's been some time since I've been to the Wheaton Library in person, but look forward to getting back there very soon. As Barry shared with you, I am a financial gerontologist. I have been working with older adults for almost 35 years and working with people at or near retirement, and I have been engaged in helping people plan successful retirements, with the foundation being estate planning. So through my company, Bentron Financial Group, I help people establish estate plans through our attorney. We implement those plans, and then we settle estates after helping people move hopefully gracefully through the ages and stages of life. So what I hope to share with you tonight are really some stories about the experiences that I've had working, right in our neighborhood here in Wheaton and Downers Grove, Naperville, right in DuPage County. A lot of work there, and then in my hometown of Oak Park and River Forest. So what I want to try to do is hopefully, again, answer any questions that anybody does have as they come along. I think people can share them, and we'll get to them. But I'm gonna not just read you slides. I'm gonna try to walk you through, again, the process of understanding what's needed, what's required, and how the whole system works for people when somebody either becomes incapacitated or dies. So it's really important that we're able to speak for ourselves, that we have autonomy, and that we can make sure that the goals and dreams that we have are accomplished through successful planning. So what I'm going to do is start by scrolling through some slides. First of all, just a general disclaimer to say that it's always important to make sure that anything that we talk about in general terms gets vetted in a personal situation, so that you make sure that anything that's said is not a personal recommendation to anybody, or not to be interpreted as tax or legal advice, but simply to have a discussion about the experiences that we've had. Before taking any action with your own plan, always consult with your advisor, your tax preparer, or your attorney. So we just want to obviously make that clear. But I think doing estate planning is, really comes from a place of caring. It allows you to make choices, not under duress. No one wants to prepare documents and sign them. The worst experiences that we had, and I went through one today, is preparing documents for somebody who's in a hospital and on their way to a long-term care facility, because when they got there, they were unconscious. No one could speak for them. The family's been having a hard time getting information. They can't get in or out of the individual's condominium. They can't get the hearing aids. There's all kinds of things happening in this case right now, all because they hadn't really done any planning, and at the last minute they're trying to throw something together. So who's the backup to the one person? The answer is no one. So it's just not the way you want it. You want to be able to do your planning without duress, with free time to think and contemplate and share ideas with the people that matter most to you. So it really allows you to understand things from a perspective that is based on experience. It allows you to organize your affairs now in a way that, again, accomplishes your goals and makes that you sure that your wishes are really carried out. I say it's easy for me to tell if someone's going to actually do planning or not based on how much they tend to love the person or people in their life. And so I always say that planning is an act of love, and people that are eager to do it show a propensity for caring. People that don't care, simply don't engage in the thought process. They'll put it off till later. They'll be very secretive. But those that say, "Hey, I really need to address this and make sure that I can really deal with it today," those are the people that seem to do it without being pushed in any way. Um, I want to talk a little bit about the system that we use here, and we're in a kind of a unique position in the United States in that we use a probate system to settle estates. Okay, and we also impose taxes, pretty sizable taxes on generational wealth passing from one generation to the next. Some of those laws have eased, but there's a lot of discussion right now, and there's a lot of proposals on the table to reduce estate tax exemptions and to take away a lot of benefits that people have enjoyed for years. So one of the things that we can do is make sure that we aren't using an archaic system like probate to settle our estate, but that we're going to use some other process, usually that of a living trust, where we can control decisions, the people involved, the timing and manner in which that we do this. So we got our probate system from Old English law, and they did away with probate nearly 120 years ago, maybe 130 years ago at this point. And we still use the system here today. So I'm gonna just kind of pepper in some stories that kind of drive home some points that I want to try to make. And the first is just that of Marilyn Monroe, a well-known movie star. A lot of people very much admire her, and she died at a young age and hadn't really thought through who her beneficiaries would be, who would really receive her things. And when she did die at an early age, she had named her acting coach, Lee Strasberg, to receive her estate. The value of her estate at that time was only about $800,000. Well, he made a claim to her image successfully, and this amounted to her estate being worth in excess of $30 million. In today's value, it's probably closer to $50 million. And it ended up all going to Lee Strasberg's third wife, a woman that Marilyn Monroe had never met. So again, it's one of those things that when you're without an easy lineage, I have 4 children, I'm going to leave it equally to my 4 children, or I don't have any family. Well, those are more difficult decisions. And so, or at an early age, maybe you have an established family yet. And so I think you really need to think through how that wealth is going to get distributed at any time, and to whom you want to leave it. So Marilyn is just a cautionary tale. And when we start this discussion, we talk about making sure that people want to reduce federal and state tax liability. Do they want to save their family from needless work? A lot of doing estate planning is estate settlement in advance. That's truly what you're doing. And who better to do it than the individual that knows and owns the asset? I can't tell you how many times beneficiaries have come to my office with a red hot statement, and I'll say, well, that's over 5 years old. I'm not sure he still has that account anymore, but they look at the value of it and I say, look how the value is close to this other account that they have. I think it's the same account, and oftentimes it is, but that account got closed and the money was moved. And you want to make sure that your affairs are organized, that what you have is easily known. And when you fund a trust, you accomplish those things kind of upfront, so there's no question about what you have. And so you want to just make this process as easy as possible on the people that you care about. And so if you want to do that, but also remain in control, continue to make all decisions, and really take care of and manage your own affairs as long as you're able to, then you really want to engage in some estate planning, and at least prepare yourself for what the inevitable is if in fact you choose not to move forward. So I always start with a discussion of what we call the four forms of ownership, because I think they crystallize what I'll talk about over and over again, which is the order of law. And I'm not an attorney, but I've worked in this industry, as I said, for over 30 years, working with probably 100 attorneys, different attorneys, in the development of estate plans, implementation, and then estate settlement. And so I've come to understand, what happens when we own property in just our own name, and we don't put a spouse's name on it, or we don't think about some other form of ownership. Maybe we keep things separate for liability reasons or for some purpose, but then at death, it becomes a little bit more difficult to access the asset. We'll talk about that. So sole ownership is when we own it only in our own name. Tenants in common is just that. It's a form of joint tenancy, but a separate and divided interest. Okay. And then there's joint tenants with right of survivorship, with which everybody seems to know. And then there's the trust form of ownership, which is a contractual form of ownership. Trust law is really nothing more than a contract between family members. And it really identifies how an individual wants their affairs managed at their death, how they want their estate distributed, and how they want their debts, taxes, and expenses paid. And so it's very straightforward document that's really just a contract, which is why trust will never be taken away. It's contract law. And it's one of those things that is the workaround for probate court. So the first question I have is, does everybody have a will? And everybody's hand should go up, because whether you've drafted a will or not, the state of Illinois has a will for you. If you are a resident of the state, then automatically you're covered under what is called statutory law, or the law of intestacy, in which you will follow the state's idea of how your estate should be distributed. So the first story I'm going to share with you is a personal one about a close friend of mine. This is over, oh boy, at this point, 24, 25 years ago now. High school friend of mine, Jim Hennigan. We got Jim Flanagan, Jim Finnegan, and Jim Hennigan all lined up at our lockers, and no one could keep us straight. And so Jim Hennigan and I became fast friends, and we're going to conquer the world together. And he went to work for the gas company out in the truck and for People's Gas up on the North Shore. And I went to work for Prudential, and we started to buy some real estate together. And things were going well. And 3 or 4 years later, we had probably, at the time, he went up to golf at a golf tournament in Wisconsin for a charity outing, and had missed a bus ride back to where they were staying, and was driving home, and a drunk driver hit the car he was in, killing him and the driver of the car. Both of them died right then and there. He was 31 years old. His wife was back in Oak Park, and she had just announced her pregnancy. And so everything was left exactly where he left it when he left on that Friday to go golf, and never came home. And so I had one of the properties that we had together in downstate Illinois in tenants in common. And at the time I thought, boy, I'm protecting my family. As it turned out, I was protecting his family, because it was that undivided interest that obligates any person to make sure that the property then gets transferred to the rightful heir of that individual. Joint tenancy with right of survivorship would have reverted 100% control to me. and we had another property that way, and he had another friend that had a property, and it was that way, and everything was turned over to his wife. But it doesn't legally have to work that way. People can change their minds if it's not legally binding. And so the idea that that he didn't have a will, so we went to probate court, his case. So anytime you have a will, you go to probate court. That's your ticket to probate court. People think, oh no, I have a will, everything's spelled out, I'll just go see a lawyer. Well, no, the lawyer then has to take the will, file it with the county, and then it opens, they then go appear, file for an appearance and go and open up a probate estate. Okay, and we're going to talk a little bit about more what that looks like. But if we don't have a will, the state has a rule for you. So when Jim died, Jim Hennigan died, he had his unborn children. It ended up she was pregnant with twins. Jamie and Tricia at this point are, graduated from college and doing very well. But the way that the state of Illinois divided his estate was they gave 1/3 of his estate to his parents who were still living, 1/3 to his wife, and 1/3 put in a trust for his unborn children. Not what any of us would think. So his parents were handing over assets back to his wife, and he was, or his family was trying to make sure, well, do we have enough resources, with 1/3 of it held in trust literally for 20 years until the girls had reached the 18 years to reach the age of majority, and then were able to access. So, all a very, very difficult time, and one that went through this system because of the form of ownership, and B, the lack of having a will. So it was a real lesson that I learned at an early age. So my definition of estate planning is simply controlling my property while I'm alive, taking care of myself and my loved ones if I become disabled, and then making sure that I can give what I want to who I want, when I want. And if I can, I want to save every last tax dollar, professional fee, and court cost possible. Sounds like a lot, but it's a simple things. It says basically I want to give the things I have to the people I love, and I don't want it to cost a lot of money. So compliance won't let me write it up that way. The next thing I want to talk about is when people think about probate, they don't always think about it. They think about it in terms of death. That's what they know most about it. But the far worse form of probate that we've experienced is probate when people live but become incapacitated. All right. And so when somebody becomes incapacitated, does not have a named power of attorney, then we're going to end up in a situation where we have to petition the court for a guardianship over the person and a conservatorship over the assets of that person. I've always said that it's a process where, again, we hire an attorney, it's costly. You have to appear annually and report to the court. We ask for permission to take care of our own family member with our own resources, and then report annually back to the court. It's almost demoralizing in terms of what I've experienced with it. And the best example of this that I can give you is another personal story or experience that I had. Was a friend of mine was a civil engineer and a consultant for O'Hare Airport. He lived up at Narragansett and 90 up in the city, and he worked at the airport and in the high-rise buildings right outside the airport. One Saturday, he got on his motorcycle and we get some paperwork from his office. And he was wearing a helmet, but when he was coming home, the rear tire on his motorcycle blew out on the expressway there, and he sustained a severe brain injury. And thankfully had tremendous insurance, tremendous short-term disability and long-term disability health insurance, because he was reduced to a physical state for a while because of the injuries he sustained in the accident. At full speed. It took a long time for him to heal. And when he did heal, he didn't come back from this. He had a severe brain injury. And I can remember when they were trying to discharge him from the hospital when they had not put the bone flap back in his head because they had removed a piece of bone to reduce swelling. And they were trying to send him home without, they said, well, we'll get to that later. And it was again, it was one of these experiences where, he's struck down in the prime of his life and basically reduced to the mental capacity of about a 14-year-old. And so his then wife, he was married for the second time. His children were fully grown. His then wife of only 6 months begins to try to care for him, but she's got no power of attorney. Nothing's been drafted, nothing's been done. So as a spouse, you don't just have the free right to liquidate someone's IRA, to sign their tax return. You have to get the proper authority to do that. And that's the process of probate during an incapacitation. So he lived at home for many, many years and was cared for at home. And as time went by, became more and more aggressive and more violent, and it became more difficult to provide care for him. So he has since been put into a facility where he's under 24-hour care, and that's then going to be the nature of his life going forward for probably as long as he lives, barring some miracle change in situation. So this is a far more difficult, I would say, death is difficult, but this is really difficult because sometimes you live with these sustained injuries for, 10, 20, 30, 40 years. So probate, as I said before, is a statutory law where in essence, we're bringing a lawsuit against ourselves. So if I think a family is going to litigate no matter what, I'll often recommend that they don't draft a trust, that they get wills, and that they end up in court from the get-go, if that's really what they really want to do. But if you want to avoid that process, avoid the court process, avoid what I'm going to talk about in a minute about the perils of probate, then you want to do some estate planning and potentially draft a living trust. I've got an excellent article. I don't have a copy with me, but I wanted to let people know that if they email me, and my email information is at the front of our presentation and at the back, I'll send anybody a copy of the article that really drives down to some of the benefits of a living trust over a will and how the two operate, but from a third-party resource. So, and then there's always the Henry App's book, The Living Trust, which is, been reprinted several times. It clearly outlines what a living trust does and kind of how it operates. So a lot of times people will go to an attorney and they'll say, well, I'd like to do some estate planning. And the attorney will say, well, your estate's not big enough. You don't have enough. Well, anything is enough. I think it's important for us to think about the fact that our estate consists of that which we own. And that is important to me and to the people that I work with. And we want to make sure people of any means have access to reasonably priced and well done estate planning. So you want to try to avoid probate because of a number of reasons, which I'll go into, but it's not just about taxes. It's important to understand that the estate tax exemption limit right now is about 11.5 million per person. So for a married couple, it'd be almost $23 million before you'd have a federal estate tax. However, in Illinois, estates over 4 million, a little over 4 million are taxed at a very high rate. I want to say 39%, but I'd have to check that number. So you can avoid these things pretty easily by doing a little bit of planning, and usually it's the use of a trust. So I want to talk now about, again, that process at death, where we talk about, what does happen when somebody passes away. Well, we, take all the assets that they have. We usually would take their will and we go to the probate court. At the same time, we're probably paying taxes. Let's say somebody died in October or November, we're going to be getting their tax return ready now. If they died in October or November and we sold stock to pay for their care, then I might be paying capital gains tax. I'm going to have the settlement of last expenses, in some cases, federal estate tax. What's left when this process is complete is what children get. Okay. It's what our kids are going to inherit from us. But the process takes a long time. Okay. It's important to understand that the average probate in Illinois is about a year to a year and a half. The minimum mandatory open period for a probate estate is 6 months. So somebody passes away, you wait and get death certificates, you do all this kind of higher level, lower level planning, stopping, the Social Security payment, stopping the Medicare supplement charge from the account, those types of things. But then you are going to go to court, you're going to file that appearance, and it's that process that has to be open a minimum of 6 months. And I said, I've been doing this a long time. We've settled hundreds of estates, and they take a long time. I won't say how long, but I'll say a lot longer than 6 months in a lot of cases. And then, again, if somebody didn't have a plan, they end up in probate. There's a lot of digging and redoing to do, meaning that, it probably means that they didn't do, if this is the death of the second spouse, then they didn't do anything when the first spouse died. So her name's on all kinds of stuff, or his name's on all kinds of stuff. And now you've got to prove that the other person died. So you really want to, when a person passes away, you want to address, some of these lower level things so that that they don't have to be redone. And you certainly need to revisit beneficiary designations. If you don't take away anything from tonight's presentation, I think reviewing beneficiary designations is a critical part of any planning that people do. Again, there are a lot of stories about people who didn't update beneficiary designations, didn't think about them, forgot about accounts that they had, and the unintended consequences are severe. So probate takes a long time. Okay. Probate is a public process. All right. I liken it. I'm going to show my age a bit, but I'm going to say it's like the wall on Facebook, which I don't know much about, but or it's like the wall in the Jewel that when you used to walk in the Jewel food store, there were all those little cards, and it'd have somebody who walked dogs or cleaned cars, or all different types of ads were up on that wall. That's how I learned that my then now he's 26 now, but then 12-year-old was cutting lawns when I saw my phone number up on the wall at the Jewel. It's a public process. Probate is like taking all your stuff and putting it out there. It used to be that people would have to get in their car, deliberately go to a courthouse, look something up. Today, these records are online. All of this stuff is available to people that want to look. They can go and look, and it's so much easier to look and find things, and for air finding services to get involved in the meddle in estates. It's really interesting how it's changed in the 25 or 30 years that I've been involved in this industry. So when you're in probate, they're gonna list your estate in the newspaper. They're gonna publish the names of your beneficiaries, all the people that are heirs. They're gonna call out, look for additional heirs. Probate is a forum for creditors and claimants to come forward and make a claim against your estate. It's not to help people other than to make sure that if you think about where it came from, it was from the Old English law and the fiefdom, where I owed Joe Brown 2 chickens. And when I died, they get the 2 chickens and they make sure that he gets them, because he goes there and says, Flanagan he owed me 2 chickens and I have to pay. And so that's the process brought forward to today. And that's why it's public. And I say it's, we lead private lives until the moment we die with a will, and we become a matter of public record. Anybody can find it. It's costly. Probate costs can't be blamed on just attorneys or accountants or administrative people. I'll tell you where the costs really sneak up on people. It's in time. It's when estates don't get settled and these things take time. It took time for, us to mourn the person's passing. Then we found out that we had to go to court. Then we went around and we took us months to find an attorney. Then we settled on somebody we liked. Then we got involved in it. Well, all the while, all the assets are exposed. Okay. So the costs come from, what's going on right now. Every time it snows, if we've got properties that are being taken care of while they're waiting to be sold, all the maintenance costs continue, the utility costs continue. Then about what happens, remember a couple of years back, the microburst came through Wheaton and took down all kinds of trees. Well, it was a bad storm, and we experienced a situation where limbs came down, and they came down on a house that was unoccupied. So it took us a little while to figure out what was going on. Then it was a roof repair, a gutter repair, aluminum siding, a carpenter for the deck, a painter to restain it. This went on for months. And because the people were out of town, they said, well, Jim, make sure you get 3 estimates. So I'm sending people from our office out to get 3 estimates on 7 trades. That's 21 trips. Has anybody ever had a contractor not show up? It was a lot more than 21 trips, but if that's what gets expensive, it's the time, and then it's all the costs because of this exposure. Anything we can do to shorten that time frame, reduce costs, be efficient and effective, make sure that people's wishes are honored truly and honorably in a dignified way is what we're trying to accomplish. Okay. The last issue that you're there is for people to contest. Like I said, they're for creditors and claimants to come forward and contest. So I want to share with you a probate story, but a non-probate story real quick. And this is a story of a son of a client of mine. He was in his 50s. He was a Chicago policeman. He had died of kidney failure. And so he had tremendous medical problems throughout his life. He never married. He didn't own any real estate. He rented an apartment. He leased a car, a Cadillac Escalade, and he had a lot of bills, a ton of bills. But then he had some things. He had some life insurance that he had taken a lot of loans out on, but he had some life insurance through Northwestern Mutual, I think in Prudential, and then he had his policeman's insurance benefit. He had his pension, or not his pension, but his 401k, his contributory plan. Okay, and there's 3 non-probatable assets: annuities, life insurance, and IRAs. Okay, those 3 assets, whether you have a will or not, they all have beneficiary designations. So those 3 are your non-probatable assets. So technically what happened was he had all these claims against him. And his mother came to me and she had the bills, and they were in a box this big. And I stewed over it. And then I thought, well, wait a second. Everything that he has is going to pass through in simplistic terms. Okay. So his mother was named as the beneficiary on the 2 insurance policies, on the 3, really, the Prudential, Northwestern Mutual, Policeman's Benefit. And then she was the beneficiary on the IRA. So she had an inherited IRA. She took the life insurance in, and we sent the keys back to Cadillac, and they said, well, what happens when you have a vehicle that still is owed money and you turn the vehicle back in, or you got to pay the loan off and keep the car and settle it through the estate. But when you turn it back in, what they do is they sell the car at auction, and then they come back later, and if they didn't get enough, they go claim it against the estate. So in this case, I think there was going to be a pretty sizable claim against the estate. But I said, oh, okay, that's not a problem. We'll wait for you. And the fact of the matter is, I knew that there were no assets for us to probate. So we were never going to file the will, and we were never going to do anything. The only other thing he had was a bank account with like a $4,000 balance. And for that, we used a small estate affidavit because you need $100,000 or more of combined assets that are not in probate to, or, if your estate is smaller than $100,000 combined of everything, then you don't go to probate. It's settled through a document called the small estate affidavit. So one was drafted, she went to the bank, and the banker was terribly mad that she could claim on it, because connected to this account was one of these credit card things where he had maxed the credit out, but as long as he kept the balance, he wasn't required to pay the balance. And then that was forgiven at death. So it worked out tremendously well. I mean, his mother at the time was in her 80s. She didn't need this. And so she's like, what do I do with all the bills? I said, let's shred them. Because there's no estate. There's no one's ever going to get anything because there's no estate to settle. So the timeshares, the timeshares cost more money than they were worth. His mother knew it, he knew it, he couldn't get out of them. Now there's services that you can use to help get out of them. But because of that, it's kind of like an elegant solution to a really nasty problem. If this guy had owned a condo or owned any real estate at all that was worth $100,000, then that condo would have been, at least that piece of real estate would have had to go through probate of some sort. And then it would have just gone to creditors and claimants, the entire estate. The lawyers actually would get their money first, and any court fees would get paid. And then from that. So, again, these are real stories of just, real life examples of situations that we've had and what happens. And so sometimes it's a matter of just looking at your situation and saying, well, how complex is it? My son already is on my house. I did that. We bought this building years ago, whatever you look at each individual asset, and then the order of law dictates how that asset would be transferred at death. So the way that we try to avoid this process is just that. It's this living trust. A living trust is a glorified will. It's a will that doesn't go to probate court, that gets settled in the privacy of your own home, an advisor's office, an attorney's office if you need to use one for some reason. We have lawyers that handle the real estate closings. We'll have lawyers get involved if it's required, but a lot of times people self-settle. Their kids know well in advance what's going on. Remember, the way that most of us leave life is through a progression of experiences, and things get put into place so that people know that they can manage these situations for us. And I think it's important to kind of remember that. So, again, I think I've made the point that probate is difficult. It's a difficult process. We want to try to avoid it at all costs. And you also want to try to work with professionals. Here's Warren Berger, who was chief of the Supreme Court for a while years ago, decides to draft his own will, and then leaves out the appointment of an executor costing him a $1.8 million estate, $450,000. A big mistake for somebody that smart in the profession. They say that John F. Kennedy drafted the Kennedy Family Trust in the Senate when he was in the Senate, and because they have it at the Smithsonian with notes, all these handwritten notes from other people who were lawyers at the time. And they said that they came up with such restrictive language that Jackie could not get money. She really couldn't get access to the money that she needed. And that's one of the reasons that she ended up remarrying, was for the ability to live the lifestyle that she was accustomed to. Which is why, obviously, you need to choose powers of attorney as carefully as possible. Family will show up. Family is what I've seen in my professional life, be the people that show up and get things done. I say they don't need to be the smartest people in the world. They don't need to be white collar professionals. If they are honest, hardworking people, they can apply themselves to get these things done for families in ways that that people find meaningful and find beneficial. So I think you can't say how important it is that you choose the right people. So take a note of that. Sammy Davis Jr. is an example of an estate that had a lot of debt in it or had obligations that actually exceeded what he owed. And a lot of times this can happen from taxes, okay? And in order to satisfy debt, you have to have a fire sale. And so in Sammy's case, he made a fortune over his lifetime, but ended up getting pennies on the dollar for the assets that he had, and it ended up being a negative result for his family. So there are a couple of things that you can do to avoid probate without getting a living trust, okay? And the way that you do this, it's different with real estate. That requires probably a more complex discussion because everyone's situation, their cost basis, the tax elements of that are so different. I think that bears a kind of a more private conversation, but bank accounts, brokerage accounts, things of that nature, you can put what are called a payment on death, POD, or transfer on death, TOD, clauses on them. So payment on death are for bank accounts, and TODs, transfer on deaths, are for brokerage accounts, investment accounts, things of that nature. All right, so you can go and I say try to put proper POD, TOD titling on every single account you have, beneficiary the other accounts that you have, deal with real estate in a different way, but that's like putting 13 Band-Aids on to avoid getting 2 stitches. It's not probably going to be the way that that really gets you to the finish line the way you want. And I'll tell you why. The biggest thing that I see happen to people's plans who are piecemeal like that, and so they don't have the same 3 beneficiaries on everything, but they got stuff broken out. In my own family situation, my younger sister was in charge of my parents' estate. As I managed money, I was precluded from doing it, but so she was the trustee. And when my parents were in a nursing home, she took money from her children's investment account to pay the bill, not knowing what these segregated accounts were. And so a lot of times what happens when people step in to manage our affairs, they go, oh, why does he have 4 bank accounts? These 4 different CDs at 4 different banks. Well, he had 4 grandchildren. That's why, and people do things. They do different things. They do it so they can remember it, so they keep things easy. But then family comes in and they take that. They say, well, we just put that 1 CD, not knowing that there were different titling interests or beneficiaries or plans for those separate accounts. So you can avoid probate in some other ways, but they're just not effective and they're not as reliable. And as I said, they're POD or TOD. When you add children to a piece of real estate before you die, they inherit your cost basis. So the implication there is a tax implication, meaning you bought the house for $47,500. You put them on as a joint tenant. It's today worth $475,000, and they have your basis, as opposed to inheriting the property when you die, and then when you pass away, they inherit it at the market value date of death. So there's a loss of basis. There's some implications that can occur when you do planning like that through just deeds and changing names on deeds. You're also exposing the estate to judgments of that child, to divorce, to any type of litigation that they might have. I'm going to check the question. Okay, and just use some. We've got the 3 non-probable assets put up there. I think that's great. Thank you for doing that. Here's an example of people having access to advisors, to counsel, to a different, really a higher end lifestyle. You'd think Sonny Bono dies at 62. I think at the time he was in the House of Representatives, leaves no will or estate plan. His then wife had to rush to receive permission to make decisions to move his body. And then there was a claim for a potential heir that was refuted, but that took time and money. And here's somebody, like I said, who has access has motive and opportunity, and then simply doesn't do the planning. So again, I think you want to try to make plans as simple as possible. And, we strive to do that. We try to make things understandable. Hopefully this presentation's been understandable. And this is just a quick story about a family that was penalized for having a Hinsdale address. They were actually an unincorporated Hinsdale, but had a modest ranch home, but it had a Hinsdale address, went to some Oak Brook attorneys. And I actually still have this in my office. It's under my desk. It's been there for 15 years. I moved it when we moved, but it's a carpetbagger suitcase with like over 1,000 pages of documents. This estate at the time was worth probably $400,000. And I have the invoices from it back in like 88, 89. They had paid like $6,000 for the work that had been done and never finished. And the Mr. McGuire got so frustrated with the process, he just ended up putting this suitcase, zipped it up, and put it away. And then met me a couple of years later, and he and his wife brought it in and said, "Will you take care of this? And would you get rid of this for us?" And we put together a very simple and specific plan that was about 20 pages long, gave him proper powers of attorney, and then effectively a couple of years, 10 years later, distributed the estate to his only son. And and it needed to be simple and specific, and that just isn't what you get all the time. And there's reasons for this, but we try to make things easy. It should be easy for most people to understand kind of the paths that you can take. So please remember that. Excuse me, a well-written, fully funded, updated, and that's important that it reflects current tax law. There's language in there that grandfathers trusts and does some things to protect people, but probably want to have a plan reviewed every 5 years. Want to make sure that the language is updated. There's been a lot of changes in IRA tax law, primarily that I would want to make sure that language is included for that, for special needs or handicap beneficiaries that we might not even know exist today, that could exist in the future, but just language to protect them that's very, very simply and easily put into documents. Just different provisions based on things that we've had happen through litigation and trusts over the years that we know will provide protections for people. So they do allow you to retain control and really allow the family to drive the train rather than being in a black box. So today's living trust package should be inclusive of the trust document itself, a power of attorney for financial, and a healthcare power of attorney. There are two different powers of attorney. You need two different powers of attorney. The healthcare power of attorney is also inclusive of a HIPAA authorization that names people that can receive information. So many times there were 7 kids in my family. So my parents had, my brother and sister named as successor powers after my mother, but then gave permission to all the children to receive information at any time on the nature of their health. Couldn't make decisions, but could receive information. We always include a pour over will. It's called a pour over because it's like a pitcher that catches anything that falls. And if there's anything that is inadvertently left out of a trust, or they're most often used when, say, somebody is in their 80s and a sibling dies, and then they die 4 months later, as long as you live 30 days past the date, you're entitled to have that enter into your estate, and we would use that document to pass that from that estate into the individual's living trust. So there are times when it comes in handy. If you have children under the age of majority, 18, then we do guardianship appointments, what we call a bequeath of special gifts or a personal property disposition. A living trust should also include the filing of a deed for your primary residence, inclusive in the pricing. So all these documents with help funding the trust should cost roughly $1,900, $2,000. All right. And the one thing that I think is kind of a litmus test for this is to say, the internet kind of tells us when we can find something wrong with something. Is if you go and say, the cons of a living trust or pitfalls of a living trust, it'll say, getting your assets in it is the only thing that creates an issue for people. Is it's just, I don't know how to do it. It's the same thing that you do when you get married or change your name. You're going to go to each institution, each place, and show them the documentation that you have to retitle the asset. So that's something that should be included in the process. Something that we try to help people with, even if they've got a trust already that isn't funded properly, we can assist with that. So all these documents together with the funding and a filed deed should then be inclusive of a pretty comprehensive estate plan. Don't put things in writing. Don't go back into your documents and cross over when your daughter gets married and you want to change her maiden name to her married name in your document. It's not necessary. We'll find out. We know who she is. Legally, they know who she is. Princess Diana left a handwritten letter to bestow gifts to her 17 godchildren. And it was never honored because it was handwritten. And instead, they gave each one a small trinket of jewelry rather than really what they had deserved and what she had asked that they receive. So the lessons of estate planning are fairly simple. And I've got a thing, it's called the checklist for estate planning. And it's a document that we created, again, that I'd be happy to share with people. If they email me, we'll send you an electronic version of it. And it's a checklist that runs you through all the different things that you should be thinking about and asking yourself, kind of not necessarily a summary of the presentation today, but something that will help you in that process. Work with people that have done this. We've done literally hundreds of living trusts and settled hundreds of estates. So it's important that you work with people that are engaged in the process and not just doing it because they've got a word processor. So it's important that you do that. And then, it's always important to keep things up to date. So if you've been procrastinating, time to get off the fence. It's 2022. And if you've got your plan in place and it needs a review, we're always happy to help with that as well. Are there any questions now that people might have?
Yes, thank you so much, Jim, for all that great information. There are a couple of questions. The first is, you mentioned that there are three non-probatable assets, the IRA, life insurance, and there was a third one. What was that third one?
Annuity.
Annuity.
So
Okay.
any annuity, whether fixed, variable, or indexed, will have a beneficiary designation.
Okay, great. And are we understanding that your suggestion is that you create that living trust first before making a will?
Well, it usually people will decide whether they want to do, if you do a pour over will, it's done at the same time you create a trust. But either you're going to do a last will and testament, or you're going to do a living trust package. Okay. And our advice is for most people, especially people that own real estate, that a living trust is usually very helpful. If somebody has an extremely simple estate, they don't own any real estate, they don't have any real tangible assets, then there might be some ways that you could avoid the living trust. But for most people with any assets that, remember, a probate action gets opened in every county that you own real estate in. So, that's how it gets dispersed, through the laws of that county. And your will would get filed in each county, and you would have representation in each county.
Okay, thank you. This question's a little complicated, so I'm just going to read it exactly as it was typed in. This person says, I've designated my living trust as the beneficiary of my IRAs and 401k plans. The change in law requiring full distribution within 10 years of death have made me reconsider designating my spouse or children as direct beneficiaries to extend the distribution period. So the question is, what factors should I take into consideration in making this decision?
Well, the first factor would be making sure that anybody that needs the money gets the money. Meaning that, first of all, if you name a living trust as the beneficiary of an IRA, there better be really special language in that trust that allows it to go to living beneficiaries, because otherwise, if you name a living trust, it will be taxable in the year of death, at 100% taxable at the trust level. So an IRA asset gets looked at really differently. If I don't have any beneficiaries, or my beneficiaries don't need any of that money, an IRA is a great asset to leave a charity because they would pay no tax. But otherwise, yeah, the IRA should be left to the family member. But I always ask this question, and the question is a simple one. If you were going to receive your parents' $500,000 home, or you were going to receive a $500,000 IRA, which one would you want? And the correct answer is, give me the piece of real estate, because I would inherit it at the value of $500,000. If I inherited an IRA from my parent, my adult parent, I would have to pay tax on all $500,000. So there's significant differences. So I would say it's a very personal question based on what the needs of the family would be, what the beneficiary designations look like, and where the tax brackets of the family are.
Okay, all right, well, thank you. And thank you so much, Jim. These are complicated issues in some ways, but we appreciate you trying to simplify it for us and helping us to understand those important documents that we need to have in place. I'm gonna just start to close up here, but if there are any follow-up or additional questions from our attendees, go ahead and type those in the Q&A. We certainly want to thank Jim and Bentron Financial Group for generously providing your time and effort to provide this presentation. I will be sending out contact links and information about the recording of this program in an email following tonight's presentation. And if you would like those links, you can ask for them by emailing me at ce@wheatonlibrary.org. That's CE for community engagement @wheatonlibrary.org. So there weren't any more questions entered.
Barry,
so
can I
good.
throw one thing out to you? I want to make sure that you guys
course.
that Wheaton Library gets a hard copy of my book, Packing for Retirement. If one isn't already on the shelves, I'll have to check with you on that. But that's another resource that people could call on. I wrote a book called Packing for Retirement. It's available at Barnes and Noble, Amazon, and it's a guide for people between 50 and 70 preparing for retirement. And there's a really detailed section in there on estate planning with checklists and net worth statements and some other tools and resources that you might use.
Wonderful, wonderful. Thank you so much. So
I will follow up with you and make sure that that's on your shelves very quickly.
Perfect. Thank you.
Thank you.
Again, thank you for your time, and thank you to everyone who's joined us tonight. Everybody stay safe and healthy, and we hope to see you again soon. Good night.
Great. Thank you very much.